Wow. I wonder what will happen in the next 10 years, whether fingerprint or thumbprint or things like that will come into place. Welcome back to Connecting the Dots, where we unravel the complexities of real estate in Malaysia. My name is Joanne. I'm your host today, and today we are very excited because we have a lawyer in the house today, and his name is Mr. KC Cheng from Vin Cheng and Co. Hi, KC.
Hi.
Yes, KC, I know this is your first time doing a podcast, and I really appreciate your time coming here. And also, this is the first time that we meet each other in person.
Yes.
Yeah. So maybe you can just tell us a little bit about yourself.
Okay, I'm a practicing lawyer.
Yeah.
My firm is Vin Cheng and Co.
Yeah.
We're located in Oval Damansara. So our specialty is an all-service law firm. We have a construction arm and we have a litigation and conveyancing arm. So my department, I specialize in family law.
Right.
And I have a conveyancing arm, predominantly because a lot of transactions in family cases may end up in conveyancing transactions.
Yeah.
Example, if someone has a divorce and wants a property to be transferred to a certain party, then end up the conveyancing department would take up the task and complete the transaction according to the court's orders.
Right. So how long have you been a practicing lawyer?
So I believe I have lost count. But this year may be my 14th year practicing as a lawyer.
Have you always been wanting to be a lawyer since you were a kid, or how do you stumble into this legal profession?
Well, it was more of I couldn't do maths.
Okay.
And my parents were, I'm from a small town and my parents are actually teachers. So typically teachers want their children to be working in certain fields, accountant, lawyers, at least during my
Where are you from?
generation.
Where's your family from?
I'm from Sungai Petani, Kedah.
Okay.
Small town.
Wow, I think we have a few similarities. My mom is also a teacher, was a teacher, and then and I was also a lawyer, but then I left lah. So good, kudos to you that you have been in this industry for 14 years. Just wondering, like, what do you find most enjoyable as a practicing lawyer?
I feel that
or fulfilling.
Yeah, I feel that practicing involves a lot of dedication and a lot of long hours. So I always emphasize, at least to juniors who come into the field, it is a field which is, there is a bitter part of it. Yes. There is also a sweet part to it. So the sweet part is to get a resolution for the clients who come to us, and they get the result they want, and that is the satisfaction we get from the case.
Wow. Did you start family law at the beginning of your career, or you actually went into it as you progress along? Why did you choose family law as your forte in a sense?
Okay, there's a story behind it. I started off practicing as a corporate lawyer.
Okay.
And when I was, I worked in several corporations, and I also entered a large firm.
Okay.
I was asked to do due diligence work.
Yeah.
And after a few months of doing it, I felt that I didn't like it. And then I decided to branch off to do general litigation work.
Yeah.
So as I was doing general litigation work, I got to know some friends, and one of which is one of my very best friends until today. He always told me this, KC, why are all the cases which come to you get settled without having to go for trial?
Yeah.
So I come to realize that I seem to attract an amicable resolution of cases. So that was when the application of this gift is to be applied in more towards family law, and I decided to branch out to family law.
So it's more like the mediation part that you are really good at it lah. Right.
Yeah, mediation and perhaps saying the right things, touching the right points to have a resolution of
that is a skill that we all real estate agents always want to have or attain, because I think it's very similar. We just want to have an amicable resolution between the buyer and the seller. And I always say that we are in a matchmaking business in that way that so long as both parties, there's a willing buyer, willing seller, and they both come to an agreement, that's it. That's how we close deals lah. Yeah, in that sense. Okay, let's dive into the first question. Today is really about all the burning questions that we have in relation to real estate transactions. And the first question comes to it is like, can I represent myself without appointing a lawyer in a sale transaction? Why we get that question is because a lot of people, as we all know, we want to save as much cost as possible. And so trying to think of ways, is it possible to save legal fees when it comes to sale transaction? What do you think?
So in a sale and purchase transaction, there's usually the vendor, the
Yeah.
seller, and there's usually the purchaser. So to address that question, it would
Yeah.
involve both parties not represented.
Okay.
This would not be a recommended scenario
Okay.
because the agreement has to be drawn up,
Yeah.
and this agreement has to be imparted to either the bank to draw down the loan or the land office to do the transfer, all of which involves a certain amount of skill to
Okay.
have it done.
Yeah.
So it is not a recommended scenario for
Okay.
both parties to be unrepresented.
Yeah.
What usually happens is that one party gets represented, example, the purchaser gets represented by a solicitor's firm,
Yeah.
and the seller elects not to be represented, and so it writes on the purchaser's lawyer
Yeah.
to help with the administrative part of things.
Yeah.
Example, the seller may need to apply for the transfer, if they're not done so, from the
Yeah.
developer's name to their own name, and then transfer to the purchaser. Or perhaps if the property is a leasehold,
Yeah.
they may need to apply to the government, to the local authority for consent
Yeah.
before having it transferred to the purchaser.
Right.
In that situation, I think that it may be appropriate,
Yeah.
or it may be more suitable
Yeah.
for the vendor to elect not to be represented, just so to save costs.
Yes.
But however, there's a caveat to this.
Yes.
If the vendor is not represented, then there's no one to assist the vendor to have his
Correct.
say in the sale and
Correct.
purchase agreement.
Correct.
So it may end up for the sale and purchase agreement is actually one-sided in favor of the
So technically,
purchaser.
a lawyer cannot represent two parties in the same transaction because of conflict of interest. Am I right?
Yes, that's
Yeah.
correct.
Yeah, so in Malaysia, is it true that it is mandatory for purchaser to elect, to appoint a lawyer? Can the purchaser not be represented, but there is a vendor solicitor on hand? Do you see these kind of cases before?
Oh yes, that happens.
Ah.
For example, in probate cases, when the estate receives a property from the deceased,
Yeah.
and the estate decides to dispose the property to the purchaser,
Okay.
and the purchaser may not be represented at that stage, you can actually have a transaction where the seller is actually represented, but the
Oh.
purchaser elects not to be represented.
I see.
Yes.
So, as in the SPA, there's a clause would say that the purchaser elected not to be represented, and that will be clearly stated there just to avoid certain complication that comes up, lah. I mean, as in both parties are aware that the purchaser is not represented, but the vendor is represented. So, in other words, let's say for a normal subsale transaction, can this still be applied in a normal subsale transaction, not in a probate case?
It may apply,
Ah.
however, it is highly unconventional.
Yeah.
Usually, by default, when the lawyer steps in
Yeah.
and the other side is unrepresented, it is usually
vendor.
representing the purchaser.
The purchaser.
Yeah, if it's representing the vendor,
Yeah.
the lawyer better make sure that the sale and purchase agreement is drafted
Yeah.
properly, because it would
Okay.
arise a dispute in future.
Right. So, what are the risks of the vendor trying to save costs and don't want to be represented? What is the biggest risk that the vendor have to be aware and he's willing to take those calculated risks in order not to be represented?
So if the vendor elects not to be represented,
Yeah.
technically the purchaser's lawyer would not be in a position where they have the obligation or fiduciary duty towards the seller
Okay.
to actually report each and
Ah.
every progress of the case.
Okay.
So a lot of times what we experience is that the vendor actually complains that the lawyer has not been updating them
right.
when they have elected to be
Yes.
unrepresented in the first place.
Okay.
So for example, there may be situations where the transaction has actually exceeded the completion date. However, it is an allowed situation.
Yeah.
Example, the redemption statement from the vendor side
Yes.
is not actually released on time,
Yes,
therefore
yes.
leading to an extension.
Yeah.
So the vendor may not be in the know. and in certain situations may even threaten to complain the purchaser's lawyer to bar counsel when the purchaser's lawyer don't owe them a duty as to a client as compared to how they would owe the purchaser.
Correct. So if that happens, I would assume that if it's already past that completion date, right, then the purchaser would then can actually incur or rather charge the liquidated damages on the vendor. Is that right? If let's say it's overdue.
So if it's overdue, the vendor is entitled to charge liquidated charge interest.
Interest, yes.
On late release of the balance purchase price. If it is delayed on part of the seller, then the purchaser can actually claim that this is the seller's fault for inability to release the property on time to the purchaser, and actually also charge back interest for late delivery or vacant possession.
So that's the whole SPA part, and just now you mentioned that there are also some administrative part with the local authority, the land office, this kind of thing. And I think in Malaysia, it is quite difficult for a layman to liaise with so many different parties to just get the property sold. So when they actually appoint a lawyer, the lawyer's duty to make sure that when would your duty be discharged as a lawyer when it comes to sale and purchase agreement transaction?
So the lawyer's duty would complete upon having the property presented for transfer at the land office, which is, and they will receive something called a presentation receipt.
Okay.
And that would be more or less a confirmation that the property will be transferred from the seller to the purchaser.
Right.
However, this is subject to certain things which needs to be complied. Example, the balance purchase price would need to be released to the lawyer stakeholding account so that it's ready to be released to the seller. Subject to the part on apportionment, meaning to say electricity, water, bills, who is to be liable for which part. The cutoff date would be the part where the property is presented for transfer at the land office, and vacant possession is actually given to the by giving of the keys is actually given to the purchaser's lawyer.
So we always have this I won't say friction, but a discussion that we always have lawyers is who is supposed to do the handover, the vacant possession handover. So what is your opinion on that?
So certainly in a lot of situations we would prefer the agent would still be involved until the stage of handing over vacant possession. But in reality, always according to the agreement, the obligation is on the seller to hand over the keys to the purchaser's lawyer.
Okay.
So if the seller is represented, of course he would know that the monies are in the seller lawyer's account. And he is obliged to actually hand over the keys to the purchaser's lawyer for it to be given to the purchaser.
Okay, but if the case where the seller is not represented, then most likely the agents will have to facilitate the handover of vacant possession. And when it comes to handing over of vacant possession, right, are there any legal documents that both parties have to sign or things like that?
It is usually goes by way of an issuance of a letter confirming receipt of the keys.
Okay.
The keys is a significant indication of vacant possession being handed over.
Right.
Even though in certain situations the possession of the property may have already been handed to the purchaser. However, the keys is a significant. It signifies that vacant possession is officially handed over to the purchaser.
You know, now makes me think that everything is going into electronic and digital, right? So maybe the seller don't even have a physical key. So what is the trend now? Because we don't do many condo sale, so I know that some condos is purely just digital lock, right? There's no physical key. So when you mention that key is such a significant thing, so how do we measure this then?
So yes, you are right. A story to tell. We have an instance where this condominium in Damansara, the vacant possession of the property was handed over to the purchaser by way of giving of the password access and the methodology on how to reset the password of the digital key. That can be actually incorporated into the sale and purchase agreement.
Wow. I wonder what will happen in the next 10 years, whether fingerprint or thumbprint or things like that will come into place. So second question is, generally the first document that the buyer and the seller sign in a sub-sale transaction is what we call agreement to purchase or letter of offer. And usually it's prepared by the real estate agency. So maybe you can just enlighten us is what is the significance of this document? Why is it important to sign a letter of such? Because sometimes a property may be sold without an agent. It could be a neighbor buying over or things like that, or a relative buying over. But I think it is still proper to have something in black and white. And maybe you can maybe just bring us through that. Why is it important to have such agreement, and what is in this document that the terms and the clauses that we need to pay attention to?
Right. The offer to purchase or the agreement to purchase or the booking form, which is commonly known,
Yes.
is actually signifies an interest to purchase the property.
Okay.
And this significance of interest is actually followed by this word, putting money where your mouth is. So to signify interest, you place a booking fee of 2%.
Yeah.
Either to the agency who is representing the seller or to the solicitor who is representing the seller.
Yeah.
So that signifies an interest to purchase. However, the terms and condition of the booking form or the agreement to purchase is still very important.
Yeah.
There has to be certainty in the terms
Okay.
to ensure that there is already an existing contract to purchase the property. There may be situations where this agreement is not actually an official agreement.
Yeah.
It may be just an indication
Yeah.
and what we call an agreement subject to contract.
Okay.
And when the terms are not clear,
Yeah.
that would mean that it is pending an official contract to be written between the parties.
Okay.
And this document will not be able to hold.
Ah.
Yeah. However, I think in the market, we have observed that most of the agencies nowadays,
Yes.
they already have quite
clause.
certainty in
Yeah.
the terms,
Yeah.
in the clauses, so that will already constitute an agreement between the parties.
Right.
However, I think parties need to be careful as to self-drafted sort of agreement.
Yeah.
You know, example, trying to say that I'm selling the property for this price. However, it may be increased to a certain price because that after I assess how much is the renovation cost and all that. So in this sort of contract, there's no certainty of terms. So that document itself may not constitute a contract entered between the parties.
So it is a void contract basically, right? They cannot. It's not enforceable in court.
Not
Am I right?
enforceable.
Yeah.
Yeah.
Okay. So what about those? I have seen letter of intent where the seller said he's willing to sell at this price, the buyer is willing to buy, but there's no consideration, meaning there's no money being paid. Is that also a void contract?
Right.
So
in this
it's
sort
just
of,
an intention. Yeah.
So in this sort of the agreement,
Yeah.
it's just an intention. You are absolutely
Yeah.
right. There's no commitment in the form of contract to purchase the property yet.
Okay.
As compared to the normal booking forms
Yeah.
with the agencies nowadays, you would see that there is a time frame to do certain things.
Yes.
Example, 14 days or 14 working days to
That's
sign
right.
the sale and purchase agreement.
Correct.
And when upon signing the sale and purchase agreement, he's to pay the balance purchase price. All these are very certainties in
Yeah.
the agreement required to form a proper contract
Contract.
between the parties.
Okay, and I think it is also known that you don't have to pay the earnest deposit to the agency. You are also you have an option to actually pay the earnest deposit to the seller's solicitors. However, some also question that can the earnest deposit be paid to the seller in their own name upon signing the ATP? What is your view on this?
Okay. Of course, I would say that caveat emptor, let the buyer beware. So if this is someone the purchaser trusts,
Okay.
then perhaps it may be a situation where purchaser may feel comfortable. But as lawyers, we always advise against it.
Yeah.
It should be placed in a certain party as stakeholder,
Yeah.
pending the undertaking of other things. Example, it could be pending production of a title.
Okay.
how would I know whether the seller
Yeah,
is the
that's
actual
right.
seller himself?
That's right.
And or perhaps pending the title search done on the property to verify that this seller is a genuine seller.
Yeah.
We have instances where the lawyer and the seller are actually in cahoots, try to sell a property,
Yeah.
and it was subsequently discovered that the seller was actually residing in United States.
Oh.
So the question is, who are these people who are masquerading
Yeah.
as the seller,
Yeah.
who came in the picture? And
Wow.
this lawyer who witnessed the signing of the seller actually went on a run.
This is the SP we're talking about, or just the booking form?
This is a booking form itself.
Oh.
It's
Wow.
possible.
Okay.
Yeah,
Okay.
because monies have already been exchanged.
Correct.
If it's a
correct.
substantial sum,
Yeah.
then it may be a situation where the
Yeah.
parties could abscond with the money.
That's right. That's
Yeah.
right.
It could also be in a situation where after signing of the sale and purchase agreement, that's possible. The
Yeah.
amount is even larger.
Yeah.
That would give the parties who are conspiring to do
Yes.
this the extra negative motivation to actually run away.
Yeah, but there are also concern some of our clients that say, hey, I don't trust the law firm also, I don't trust them, what if they also run away with the money, and so maybe you can also advise like, what is the meaning of stakeholder? When we say stakeholder account, it doesn't mean that it's the law firm's account, but it's the client's account, right? And if really in the event that the lawyer really just run away with the earnest deposit, what can the buyer do or the seller do?
Right.
Yeah.
So always check to prevent this situation. Prevention is always better than cure.
Yeah.
Always verify the law firm, how long
Okay.
has it been,
Okay.
and also verify the lawyers there.
Okay.
Because some firms may be formed recently, but the lawyers
Yeah.
may be already, this can be checked in the Bar Council website.
Yeah, that's right.
And if everything proves to be legitimate,
Mm-hmm.
then you can proceed with this transaction.
Okay.
However, if there arises a scenario despite the due diligence taken, that the lawyer actually runs away with the money,
Yeah.
although they are not supposed to do so because
Yeah.
the client's account is a regulated account.
Correct.
The lawyer is not supposed to touch these monies.
Yeah.
So if indeed this sort of situation happens,
Yeah.
then it becomes both a criminal and a civil case.
Mm.
One possible avenue is to claim for a certain compensation from the bar council
Okay.
compensation fund.
Okay.
However, the amount may not be sufficient to cover the loss of the
Okay.
victim.
Right. So, and you mentioned also criminal charges. So how would they go about it? Is it to make a police report to start the case going?
Yes, so it's a criminal breach of trust.
Yeah.
Make a police report against the parties involved,
Yeah.
and push the police to take action on these parties.
Wow. So I think due diligence, the key take-home point, due diligence is very, very important. Even though you say that you may not know, but the best is to check with the Bar Council website on the number of years of the law firms and the number of years of the lawyers involved.
Yes.
Right. Okay, and I think same thing goes with real estate agency. Is also you can do due diligence on the reputation of the agency and things like that. Apart from a lawyer and agency, is there any other stakeholder account that they can actually transfer to? Not really, not common, right? Usually, I think it's only these two.
It is better to have the monies deposited in a trust account. So that's a reason why it's called a trust account.
Yeah.
So the trust account is someone you place your
Yeah.
trust to with
Yeah,
these monies.
that's right.
So
Okay.
our recommendation is always have it placed in a trustworthy or reputable
Okay.
estate agent's
Yeah.
agency's
Yeah.
account or the solicitor's client's account.
And I think in the agreement to purchase or the booking form, usually there will also stipulation on the vacant possession, like this property has to be sold in a vacant possession or non-vacant possession. So what is the difference between non-vacant possession and vacant possession?
Right.
Yeah.
So it always goes back to what has been agreed between the parties.
Okay.
So the term vacant possession
Yeah.
doesn't mean that the property has to be empty,
yeah.
before I hand it over to the purchaser.
Yeah.
So the term vacant possession means that nobody is occupying it.
Okay.
It is given, the legal possession of this
Okay.
property is given to the purchaser.
Okay.
So if in the sale and purchase agreement, it is agreed that all fixtures and fittings, example the chairs, the table, are to be there and is to be given to the purchaser. It must be there when vacant possession is given to the purchaser.
Right. Okay.
Assuming if the sale and purchase agreement says that all fixtures are fitting and fittings are to be removed before handing it over, so the seller has to ensure all these are cleared before he hands over the property to the purchaser.
But usually we don't stipulate it to that detail of what is included and what is not until the SPA stage. So we're talking about just booking form, and usually booking form doesn't tie in with inventory list. So there will be some argument that will happen while drafting the SPA, I would think. So is that where real estate agent come into place to try to negotiate and talk things through again before the SPA is signed?
So I've seen proactive and not so proactive estate agents.
Yeah.
Certainly, proactive estate agents, they would ask the right questions to the seller and the purchaser, and whether or not all these fixtures, all these furnitures, and these conditions, whether it's acceptable. They will take photos, they will take videos, and all these photos and videos can actually be inserted into the sale and purchase agreement.
Okay.
And that would ensure that the condition as is, based upon the point of viewing, is to be transferred to the purchaser.
And non-vacant possession, how does that look like?
So it would always, the legal term is always vacant possession. However, there may be a situation where the property is transferred with the tenant.
Yes, correct.
Or it may be transferred with a certain condition. Example, there's a mezzanine floor in the property.
Okay.
So all these needs to be ventilated properly upon the signing of the sale and purchase agreement. So as much as there's a proactive agent, there will also be a proactive lawyer involved. So it depends on the lawyer engaged, whether proactive enough to ask the right questions.
Yeah, just now you mentioned that word as is, where is, which I think it will bring us to a question here is, what does as is, where is really mean? When, we have dealt with so many cases recently where after booking form is signed, that's where issues arise between buyers and sellers. And for example, what I can give you is very recently, I think just 2 weeks ago, booking form has been signed, the earnest deposit has been paid. But after that, the seller got a complaint from the neighbor about a leakage that is from the seller's house that went to the neighbor's house. And this issue was, the seller was not aware when he signed the agreement to purchase. So right now, the seller feels that, she doesn't need to fix it. She has no legal obligation to fix it because we already signed as is, where is. I have stopped the leaking in a sense that she just closed the stopcock. She didn't send someone to go and fix it, and she will not do anything about it. So of course the purchaser was very angry when we alerted them about this issue, and we have an obligation to tell the purchaser that, okay, this is something that happened after ATP has been signed. So now I think both lawyers are involved already, and I'm just curious, really, the as is, where is basis. Sometimes agents use it as like a shield from, okay, that's it, we're not going to do anything about it. Or the seller will use it as like a weapon to say that, I'm not going to repair anything. I already sold it to you. Anyway, you're going to do renovation. Why not you go and do it yourself? So how should we handle this kind of situation?
So the best way to prevent this sort of situation is when, upon inspection of the property, always have the defect expert or the inspection expert available to examine the property to make sure that there's no leakage, there's no defects, structural defects to the property before actually signing the ATP. It involves a certain cost, certainly, but it is better to be safe than sorry.
Okay.
However, if it really happens, then it will boil down to the issue of a dispute as to what was promised by the seller to the purchaser. If the seller did not promise anything as to the condition of the property, then the purchaser may be at a loss because this was never promised. So the seller can actually rely on the sale of the property on an as is, where is basis, provided that this is actually stated in the ATP.
Yeah, so which means as is where is, how does the court view this term? If it's just a simply, yeah, this property is sold and agreed by the buyer that it is an as is where is basis.
So the court would view this as an obligation on the purchaser's part to do all the necessary checks
Right.
to ensure they know what they're buying into.
Okay.
So the obligation is on the purchaser to make the necessary checks.
Okay.
So as long as this term is in, it's certainly a risk on the purchaser's part. So the purchaser needs to be very careful when they see this word.
Right.
Yes.
It's not on. Oh, okay. I always thought that it's the seller's obligation to make sure that the condition is as is where is when you hand over, but it's actually. So in other words, the purchaser actually have to raise a reasonable doubt in court. It's the burden is on the purchaser side.
The purchaser would be
Proof
certainly
that they have
need to prove that
inspected properly and
Yes,
whatnot.
yes.
Ah.
there's a
Okay.
way to overcome this
Yeah.
also. I mean, if the seller has made certain promises,
Okay.
example, the purchaser assures the seller, the purchaser that don't worry,
Yeah.
there's no water leakage here.
Ah.
Don't worry, there's no
Ah.
flood here.
Ah.
Don't worry, everything
Yes.
is fine.
Yes.
You know, so if there is such a promise made, if it's tracked in some form, for example, if it's tracked in WhatsApp and it's tracked
Yeah.
in the form of email,
Yeah.
then the purchaser can actually use this
Yep.
and state that there is a representation made by the seller and actually have this terminated
Yeah.
because it was a promise made by the seller.
And when you mentioned the word representation, when it comes from an agent's mouth, does it constitute a representation from the seller as well?
It does because it is the seller
Agent, right.
who engages the agent.
So it's very important what the agent says also lah. We shouldn't be over-promising if we do not know the exact issue. So when it comes to this case, the seller actually was not aware of the leakage only after ATP is signed. And the buyer agreed to put in this clause of as is where is basis. And right now, I'm just thinking that actually the buyer's loss that this happened, and can the buyer actually pursue any legal actions against this seller?
Again, it goes back to whether there was any promise made on the seller's part.
And who bears the burden of proof to prove there's a promise made?
It is on the purchaser.
Ah.
Yes.
Wow.
This is under the Evidence Act. No
Okay.
choice. You're going to bring a case, you got to prove your
You have
case.
to prove your case, right?
Yeah.
Okay. So the advice you give is really to get a professional defect liability guy to come in to
Yes.
inspect. And I guess when these kind of professional people come in and inspect, they will of course produce a report. And then does it mean that we can also attach the report to the SPA?
Yes, certainly.
Ah,
It can be
okay.
a situation where you attach it to the sale and purchase agreement. And of course, don't forget, you need to say whether the purchaser accepts this
Yeah.
or the purchaser expects the seller to actually rectify this before transferring the property to the purchaser.
Okay, interesting. Wow, today I really learned a lot. I didn't know that the purchaser's risk is actually higher than the seller. And when it comes to when the seller refused to remove properties because it's vacant possession, and only fixtures and fittings are to be remain in the property when it comes to the day of handover. But for this particular house is where there are still furnitures around, but the SPA say that only fixtures and fittings, not furniture, right? And the sellers refuse to move those things out. So what can the purchaser do when it comes to this kind of matter?
So again, go back to what was promised. If they're supposed to remove all these things, the seller is supposed to remove before transferring the property to the purchaser. The purchaser can call for a breach if the seller refuses to remove all these things away from the house, and can actually claim for all this cost of removing all these things from the house from the seller.
Oh.
Yes.
Okay. All right. Wow. I think that's why when it comes to all this detail, I think many agents or sometimes lawyers will often overlook, and they will always assume that, this is standard practice. It's a standard practice that seller is supposed to remove all the furniture. It is standard practice that the as is where is basis mean that the seller has an obligation to maintain the condition as it is until the handover. So all this assumption that's being made, how do we then educate buyers and sellers to be a bit more careful, and sometimes is it really true that we should always be so extra careful until we became very fussy and picky on things like what's your view on that?
My view is always on the engagement.
Okay.
Perhaps a better way is for the agent and the purchaser, together with the purchaser's lawyer, to be engaged from the start, so that things can be discussed between the parties and any doubts dispelled before actually signing or proceeding with the transaction.
Right.
That would perhaps help a little bit. Of course, that would lead to a situation where the signing of the ATP may be a bit difficult.
Yeah. Exactly.
However, if the purchaser is fairly comfortable with the condition, then I think they can proceed. But certainly, the purchaser needs to be aware or be careful of what the purchaser is buying into. Because it's not cheap, it is an expensive acquisition.
Yeah, I know. But I like your approach, me as a lawyer, that you would always try your best and to promote amicable resolution even before we go into the whole who is supposed to be responsible for what and what not. Why I say that is because I think in my experience as a real estate agent, when I deal with lawyers, it's when we start to pass the case to the lawyer, right, things became really bad. Like everything is like, your lawyer say that, because everything is in emails when it comes to lawyer side. When it comes to real estate side, there's still phone calls, there's still WhatsApp. It's still a friendly environment. But when it's in the SPA stage of drafting an SPA, what I realize is the difference is it becomes very cold. Everything is exchanges of emails, and sometimes we do not know the intonation and the words being used by lawyers. Then it starts to trigger the emotional part of the buyers and sellers. I'm just curious for you, in your experience, is how do you normally deal with your clients when it comes to sale and purchase agreement? Do you take like the really strict cold approach, or how do you manage the agent part, the buyer's part, the seller's part? Yeah.
I think it is a common epidemic to be typing messages or writing emails out. I think that whenever the lawyer, in exercising his duty, feels that there's a certain risk that the message might not be delivered correctly, always pick up the phone and call. It seems to be a simple thing, but it's also a very hard thing nowadays.
I agree.
Because before even calling, the lawyer may be having the expectation that, look, even if I call, the call may not be answered. All these are just stories which may be in the service provider's mind, which may not be the actual situation. So sometimes it's not so good to be thinking too much. When there is a risk, as professionals, we should always mitigate the risk. That involves calling, trying to find out what's happening, and because end of the day, it's not litigation, at least not yet.
Exactly.
So making sure both parties come to terms. That's most important.
Okay, I really like your approach, because not all lawyers have carry the same value when it comes to things like that. I think last question. I think we are definitely going to invite you back for the next episode, because it's just so many questions that we actually gather some of the questions from our other agents and real case studies. I think one last question to wrap up is about the refund, or in what situation where the seller can forfeit the earnest deposit, and in what situation where the purchase can get back the refund of the earnest deposit. Am I right?
Right.
So, yeah.
Okay, the seller, so it depends on who is in the right and who is in the wrong. If the innocent party terminates the agreement, then the innocent party is to get back whatever money is paid. On top of that, they can actually have a penalty clause which is quite common, and is usually 10%. Claim for the 10% because of the failure of the other party to actually proceed with the transaction properly. So going into details, like let's say the seller, in selling the property, the purchaser suddenly refuses to continue with the transaction. The seller can actually decide to terminate and then forfeit the 3% paid by the purchaser. On the other note, if the purchaser, upon purchasing the property, the seller suddenly refuses to give documents or give up the title to the lawyers to actually do the transfer, then the purchaser can actually exercise two things.
Okay.
One, terminate and claim for all the losses arising from this unlawful termination of the seller, or force the seller to actually continue with the transaction and have it transferred to the purchaser. And a point to note is that what if the seller still refuses to sign even though the purchaser wins the court case? You can actually have a provision to say that the registrar of the court signs on behalf of the seller to actually have the property transferred to the purchaser. That is one thing further which the litigation lawyer should think of when doing the litigation part of the case.
So this whole cause of action or this remedy is called specific performance, and I think for this one, normally what are the winning chances for the purchaser to get really want back the property that he booked it?
So the mode of filing this is called originating a summons.
Okay.
So originating summons means that there's not much things in dispute. The agreement is not in dispute.
Okay.
The court just is required to adjudge the situation based on the sale and purchase agreement as to whether the specific performance can be allowed. So long as the sale and purchase agreement was drafted properly and all procedures followed according to the normal conveyancing practice, then the purchaser's risk is highly mitigated. So it is a straightforward case from the litigation point of view to have the specific performance imposed on the seller.
Is it often though? Is it very common, specific performance from the purchaser?
It is a common remedy.
Yeah.
It is a common remedy. And I think that, of course, certainly a lot of purchasers do not want to undergo litigation process. But there are situations where a purchaser insists to undergo the litigation process because they know that the property value has rose
increased
considerably. So they want the property. So that when there's a money at play, they may run through with the specific performance and get the result they hope for.
Wow, very interesting. All right, unfortunately, time is running out, and I really appreciate and learn so much from you in just such a short 45 minutes time already.
Thank you so much for inviting me.
Definitely need to get you on second round. So that's it, listeners. That's about it for today's episode. We are on Instagram, TikTok, YouTube, and Facebook. So do follow us and subscribe, and I will see you next time. Bye.
Bye.